Good morning, everyone. So, welcome to the daily news analysis session on 3rd July 2026. So, we'll be covering 5 different stories today. The first one, that is a conflict between state government and judiciary, state versus judiciary conflict, mostly evolving from the recent Madras High Court ban on cow slaughter and the Tamil Nadu government's protest against this in the Supreme Court. So we'll see what are the arguments put forward in this particular Madras High Court order. We'll see what are the stance or what are the arguments put forward by the Tamil Nadu state government and so on and so forth. What are the broader associated debates related to this? This all we'll see in the first particular news. The second news is related to, you might be aware, the WhatsApp is coming with a new feature, that is a username feature, where you can just share the username with the contacts or with your XYZ people and start communicating instead of sharing your personal mobile phone number. So this feature already exists in Instagram, in Telegram and other social media platforms, but WhatsApp is introducing this. Now the conflict is the government of India, or especially the MeitY, has asked for a 3-day hold on rolling out this particular feature in India. Now there are certain concerns put forward by MeitY regarding this feature being introduced in WhatsApp, and this we will be discussing in this. What are the issues related to this? What are the concerns of the government? What are the rationale of the WhatsApp in implementing this feature, and so on and so forth. We will see in this particular news. Now, third, this is a particular news from the ideas page of Indian Express. It speaks about the geopolitical aspects of artificial intelligence, especially these certain models of Anthropic, which has been banned or which has been stopped by this US government and the aftermath of it. So why I particularly put this news in this is because of some of the excellent usage of keywords in this. You can see some of the new ideas, you can see some of the new aspects of artificial intelligence in this, and which has been quite interestingly explained using some of the keywords. And definitely you can see even in newspapers, the 3 news we took today is somewhere connected to AI or directly related to AI. And AI has been one of the sensational topics throughout this year, and there is high chance in mains 2026 there will be some questions related to AI. So you can use these keywords, you can use these examples. Fourth news, when AI lies in court. Again, the usage of AI in judiciary, that is the major topic here. Now, should we allow it or should we not allow it? Now, regarding Supreme Court in this particular case has taken a clear stance regarding this. Supreme Court completely banned the use of AI in judicial decision making or judicial research. Now, why? And it squashed in previous order by NCLT, which used AI in this. Now, what are the concerns raised by the Supreme Court? Why Supreme Court takes such a one-sided stance? Now, why India as a country, or the state of the criminal justice system in India, the case of state of judiciary in India, why we still need AI in judiciary? Why AI can be an opportunity to revamp Indian judicial mess? So all these aspects we'll be discussing in the 4th article. 5th one is a particular report, that is UN AI panel report, which has been put forward by UN. Again, this discusses some of the upcoming harms of AI and some way forward related to AI. Again, similar to the 3rd topic we have discussed. So these 5 articles we will be discussing in new detail in today's session. Let's start with the first story, that is Madras High Court's blanket ban on cow slaughter. Again, Indian Express page 2, you can read this particular article. Now, Madras High Court has put an absolute blanket ban on cow slaughter across Tamil Nadu. The Tamil government appeals to this in the Supreme Court, which is the basic pretext of this particular news. Now, when we speak about these kind of topics like cow slaughter ban or religious aspect or the state government interfering in religious aspects, the major conflict is between religious and cultural rights versus the state power to regulate trade. This was the case in Shabarimala case. How much state government can interfere into this? How much state government can regulate the aspects of religion? This was the same in case of triple talaq. Now, when it comes to cow slaughter or this particular case, there is a slight difference. The case is between judiciary versus state in a broader sense. So this is the major conflict here. Now, what are the arguments put forward by the Madras High Court regarding to support this complete absolute ban on cow slaughter? The first one you will be well aware of, Article 48 DPSP. What this particular article says, explicitly called for prohibition of cow slaughter. Now, this is the base for all animal prevention, Prevention of Cruelty Act, and all other related activities that is going on. That this particular Gandhian DPSP. Now, as you can see, the conflict related to cow slaughter, the debates related to cow slaughter, that is not something that is in modern. It dates back to earlier times. It has been a conflict in India's freedom movement as well as in the Constituent Assembly. So the Madras High Court again draws inspiration from Constituent Assembly debates. The stance of Gandhi. Gandhi was so much in support of this prohibition of cow slaughter. Again, if you look at the complete stance of the Gandhi, there are a lot of nuances within Gandhi's stance. Gandhi was strongly in support of prevention of cow slaughter, but Gandhi was not in support of bringing a complete ban law throughout the country, because again, that brings a conflict. India is a land of pluralism, and this goes against pluralism. Again, this puts a lot of limitations on a lot of communities, which is why Gandhi stands. Even though we call Gandhi as somebody who is a propounder of ban of cow slaughter, there are nuances within Gandhi stances itself. Again, third major aspects to essential religious practices. Now, what is essential religious practices? Which cannot be curtailed or which cannot be regulated by judiciary or state in India. Now, if you look at the specific context of this cow slaughter ban is related to these Islam festivals like Bakrid and all. It is during this time, these debates, or this is the particular context of this particular case. So, cow slaughter during Bakrid or Eid, that is not a part of essential religious practice of Islam. So, there is no legal backing required for this particular act. So that is again third stance of this Madras High Court. Fourth, Madras High Court also drawn from a Tamil Nadu government order from 1976, which had earlier called for complete ban of cow slaughter. So this again related to like implementation of this particular order, that was 1976 order, that was the legal backing to this particular act by Madras High Court. So four major aspects. One is DPSP, the second one is the Constituent Assembly and Gandhian debates, Gandhian idea and Constituent Assembly debates and Gandhian ideas. Then we have essential religious practices argument. Then the Tamil Nadu government order that was prevailing from 1976 related to ban of cow slaughter. Now, what is government stance regarding this? The most important conflict, which takes this to a broader conflict between DPSP on one side and fundamental rights on the other, that is the argument of Article 19. That is, Article 19 put an unreasonable restriction on the right to trade of different communities including this butcher community, including the traders, including exporters of meat, including the holders or the bearding community or the farmer community. All these communities' rights are somewhere or the other connected to this cow slaughter or slaughter of the cattle, and their freedom to trade rights are being harmed by this complete ban. So this is the most important argument put forward by the state government. The second, again, the state government is saying that there are already existing state acts related to this. There is this Animal Preservation Act of 1958, which regulates the cattle slaughter, which puts some numbers like 10-year-old cattle certified unfit for work or breeding can be slaughtered. So there is already existing regulation related to cattle slaughter in the state. Again, there is economic aspect related to this. That means if you are not allowing the cattle to be slaughtered, and if it is aged, if it is unfit for work or breeding, then what we will do with these cattle? You can see this menace in many of the North Indian states where the cattle are wandering in the streets, becoming a social nuisance, becoming a traffic hazard, and so on and so forth. So who will take the responsibility of the cattle? Should the farmer keep the cattle till it dies, or should the government come up with some infrastructure or gaushala or some setup like this? And until it is not in place, who takes the responsibility of this? Now, this again, if the judiciary is going against an existing state government act, then again it is considered as a case of judicial overreach, where judiciary is making laws which is somewhere going against the laws that is made by the state. So this is third major argument put forward by the Tamil Nadu state government. And fourth argument is related to, again, when the topic of cow slaughter is coming, there is always an argument on cruelty to the animals. Now, the government is saying that there are certain provisions or regulations related to under the Prevention of Cruelty to Animals Act 1960, and all these regulations or regulatory aspects should be made compliant. And the government is asking for, within the particular act, by complying to this act, there should be permission to slaughter certain cattle, including cows. So this is the four different aspects on the basis of which the Tamil Nadu government is countering the Madras High Court order in the Supreme Court. Now, we are not going into a conclusion of this. This is an ongoing case, so we'll see what will happen in the future, and then when the news comes, we will discuss it further. So far, you can have your own debates, you can have your own stance on this particular topic. Let's go to the next important story of the today, that is related to the WhatsApp. WhatsApp has came with this @username feature. Now, this feature, like normally how WhatsApp works, you have to put the number, then the contact will come, then your message, and so on and so forth. Now, instead of number, it is now you can put a particular username, and through the username you can connect with the particular user, and so on and so forth. You don't need to share your phone number every time you need to go and have a communication in the WhatsApp. So this is the major idea of the username. You already know this. This already exists in Telegram. This already exists in Instagram. So this feature has been introduced in WhatsApp. And MeitY has issued 3-day notice asking WhatsApp to halt this particular feature and rolling out in India. Now, why WhatsApp is introducing this particular feature? Let's start our discussion from this. Again, enhanced privacy. Sometimes WhatsApp has become such a common medium, and every time you need to talk, send a message to WhatsApp, you don't need to send your personal phone number to the person, which may be linked to your banks, which may be linked to your all the other personal aspects. PAN card, income, all these related things are connected to your phone number. So every time you need to message to some strangers or casual messages, you don't need to share your phone number. You can just share your username and have communication. So privacy is the major concern. This is where in this debates related to WhatsApp, you can see the 2021 IT Act rules. And these rules calls for this origin or source of messages. And if this platform has to reveal the source of message or origin, then they have to analyze the message, then they have to dismantle their encryption features. So when this particular rules was put in place regarding this encryption breaking, WhatsApp has already reached out to Supreme Court regarding this, and it has got the verdict in his favor, and the encryption feature is still continuing in the WhatsApp. So this is another legal conflict. This can potentially become another legal conflict between the government and the WhatsApp. So there is no private directory. What are the other arguments? Let's move to the other arguments. Again, there will be no private directory. That means now what you can do, you can press some XYZ numbers in WhatsApp and the photo will be revealed. The public name that or the public details that is made public by the user will be revealed. So this again becomes a source of manipulation, the source of crimes, and so on and so forth. So this is again improved. No private directory again is enhancing the aspect of privacy. User key means if you have to message to some XYZ username, there can be an enhanced feature like introducing a PIN. Only if you have the PIN number, you can message this particular person. Brand consistency, again, brands will be having one single name in Instagram, in Telegram, so it can have the same particular name in the WhatsApp also, irrespective of which phone number or whether they have phone number or not. Again, reserved VIP handles like Amitabh Bachchan or with some Narendra Modi. If you have such, you cannot let the scammers or others use such kind of names. So you can reserve such high profile names like SEBI, RBI, these kind of names you can reserve it. Again, this improves the credibility of the. So these are the broad arguments of the WhatsApp, why it want to come up with this username feature. Going ahead, why government is pushed it back at least for 3 days. The major argument is surge in cyber fraud. Cyber fraud is happening, this including the cases of digital arrest are mostly happening through WhatsApp. And now what is happening, if somebody is using WhatsApp, there is a phone number associated with this, and this phone number will be having KYC done. This will be having some other linkage done if it is in India. So this will give these and law enforcement agencies some kind of track to look forward when this particular crime has happened. Now, if you are replacing this phone number with a username, then the trail of this Aadhaar KYC that becomes more difficult to implement, which makes the work of law enforcement agencies much more difficult. So this is one major reason. Again, the cyber fraud, the digital arrest, this mostly targets digitally unaware people or digitally less aware people. So again, a country in India where there is a huge base for WhatsApp and digital technology, there is concern on misuse of this particular feature. Second, lookalike threat, like HDFC Bank help username, they can manipulate some few words in this and come up with another similar looking name, and they can impersonation risks are associated with this. Industry backlash, again, the major backlashes came from the founders of Paytm Mobivic. Why they are concerned is because in many of the cybercrime cases, the cybercrime initiates through WhatsApp. Now, when the money is transferred, this money is handled initially through Paytm, Mobivic, and these platforms. Now, when the case or when these law enforcement agencies comes into picture, they faces the backlash. So they feel that this particular feature will give an open hand to these scammers, and this will become a conflict to or a challenge to their own existence or security. So these are particular aspects. We already discussed this law enforcement hurdle, surge in cyber fraud, law enforcement issue, lookalike threat, and industry backlash. These are the major reasons why government, at least for 3 days, has halted the implementation of username feature. Let's see what will happen when the news comes or update comes after 3 days. We'll have further discussion on this. Going ahead, third story of the day, that is, again, I told you before, that is related to AI and geopolitics. Now, what is the major context? The context is US government has imposed and shortly lifted export controls and Anthropic's AI models. Particular model was the Fable. Fable, when it was introduced, the US government said this is so much advanced model and it poses certain threats to US and its apparatus. So that it issued an order to US government, issued an order to Anthropic, asking to restrict the usage of Fabric to US citizens only. Now, what Anthropic or Cloud done in this particular context, it completely pulled back the Fable, withdrew Fable from its model. Then later on, it is after making some tweaks, it has been reintroduced, even though it is not reintroduced in India so far. So this is the particular contract. Mythos is again a advanced model by Anthropic, which again its usage is not made public due to so much of concerns of having this much of a highly advanced tool rolling out into the hands of people. So both these models has created new kind of tensions or new kind of issues among these technology leaders as well as governments. And the response of the US government, that is trying to control, if you like track the US government response in the last couple of years, you can see in 2025 the government has came up with chips export limiting orders. Countries, especially China, especially and Chinese related countries, has been banned. Nvidia and all these companies has been banned from exporting advanced chips to China and other associate countries. Now this is becoming more worse in 2026, where these particular models has been clamped down by US government. Now this particular clamping down by government on technology, that exactly is called weaponization of AI. This is exactly what we are seeing right now. US, which currently holds huge technology gap powers, where these major AI developments are happening, where the major chips design developments are happening, it is trying to have this monopoly. It is trying to control who controls the next century through AI. For that, it is trying to restrict others' entry, others' use cases into AI, which is termed as weaponization of AI. So again, structural gap for followers. Again, what is structural gap for followers? Again, when the AI was initially introduced, there were some AI companies or countries, we can say, countries which make this AI technology. To great extent, US, and some models has been made by China also. Now, there are other countries which are AI followers. Now, this country, what they have is data. This country, they have is tech. You can like correlate this with the colonialism phase. During colonialism, we were having countries like India were supplying was having raw materials. What the countries like UK or England was having was tech. Now we supplied raw materials to these tech or these industrialized countries, then we imported the finished products from them. And in this whole cycle, the countries who are supplying raw materials and buying these advanced products were at loss. Now this is the same that is happening in countries like India, which currently doesn't have the technological prowess in AI. What they have to a huge extent is data, and this data we are sending to AI companies, the AI giants, and what they are giving us is different AI models. Now with every cycle, with every repetition, this is happening more, and the tech companies will have access to more and more data. And what this happen is different from this earlier colonialism period. The gap between the countries that is having control over AI and the countries that doesn't have control over AI keeps on increasing, like inequality figure. It keeps on increasing and increasing, and it reaches a point where the AI followers cannot aspire to bring up or come up with new models and so on and so forth. So this particular problem, that is the increasing of gap between AI haves and have-nots, this is particularly called as structural gap. US gatekeeping strategy, again, the gatekeeping, the literal meaning of it, the US is standing at the gate and decides who should use AI and who should not use AI. So this is what we see in case of Anthropic, Mythos, and Fable. So these are three particular keywords, interesting keywords, new concepts in this particular news, which I found interesting. Let's go ahead. The fourth news of the day related to AI in judiciary. Now, what happened is this NCLT judge, he used AI tool for legal research. Then he gave the verdict. The problem was this: in this verdict, there was so much hallucinated cases or case laws. Hallucinated case laws, matlab, there are laws which doesn't exist. AI simply make or fake these laws, fake the verdict, fake the year, fake the data numbers, everything, and they present it like an original existing case law. So some certain case laws, fake case laws, hallucinated case laws has been found in this particular order by NCLT judge, and that's why it has been contested in Supreme Court. And Supreme Court took a decision that completely struck down the order by NCLT and asked for complete banning of AI in judicial research and judicial order. Now, what is the rationale of Supreme Court in regarding this? Subvention rule of the law. That means rule of law goes for a toss, because the case of law is itself being questioned here, because AI is coming up with laws as it likes. So what citizen get based on law, that becomes a question. Again, it is coming from the problem of AI hallucination, violation of natural justice, right to fair trial, right to following of due process, all goes for a toss if the base law itself is being questioned. Black box problem basically indicates that how we have different open model of AI and we have closed model of AI. Now, what is an example of open model of AI? That is this these are open model of AI. Closed model of AI is like ChatGPT, or clouds, Anthropic's cloud, and so on and so forth. So in open model AI, what happens is we know exactly what is the mechanism going on, or how this particular decision, or how this particular research has been formulated, what are the bases. All this information we can extract by looking at the base code. In closed model, this base code is not known to us. So that means how the AI reached a particular decision, that we still doesn't know. We just see the output, and this creates a black box problem, or the black box paradox. We doesn't know how AI particularly reached this conclusion. And when we apply this in judicial cases, what happens in judicial cases, when a judge gave a verdict, there is 100% mandatory that the verdict should contains the reason also. It should be a reasoned judgment. And reasoned judgment, when this Anthropic or cloud or AI is using, there is a question how much you can rely on this, because the internal working, the internal setup, or the internal reaching of the conclusion is still unknown. Amplification bias. This we can see in US, over when certain experiments has been done, where the case files has been uploaded. The AI verdict was found to have a severe bias towards black people. Now, why this is happening? Because AI is working on data. This data is derived from society, and this society is having so much of biases. Already there is a bias in the society. Already, if you look at the all existing cases or concluded cases in the US in last 20 years, there is huge number of black people. And so this bias has been taken up by AI, and this bias has been amplified by AI into its verdicts, its conclusions, and its decision making. So this can happen in India regarding caste lines, regarding region lines, regarding religious lines, and so on and so forth. So these are 4 problems regarding cited by Supreme Court regarding use of AI in judiciary. Rule of law concern, natural justice concern, the problem of black box, amplification bias. Now, on the other side, we already know the state of criminal justice system in India and the state of judiciary in India overall. There are 5 crore plus pending cases. There are immense delays in decision making. So in this context, to clean up our judicial system, AI can be an opportunity also. It can be used to clear the backlog. It can be used to streamline the pre-trial work. That means the administrative work related to this. All this can be efficiently handled by AI. It can also help in legal research. It can also do a predictive justice. What is predictive justice? Because before judgment, it can give some percentages on what is probability of this judgment, where it is going based on these initial data points that is fed to it. So this has been implemented in Singapore, where certain cases when the trial is going on, the data points will be given to an AI model, and a predictive justice numbers will be extracted out of this. And the final judgment go against or go in favor of this, but the people who are engaged or the stakeholders will get a fair idea on what can be the outcome of this particular case. Now, way forward, that is more important. All these benefits, if you need to extract, there should be some limits put on AI, which includes operationalization of these 2026 draft regulations, which again put limits on AI, like where you can use AI in administrative aspects, where you cannot use AI, especially it cannot be used by lawyers in drafting the arguments or drafting the cases due to these hallucination effects. Mandatory disclosure standards. Whenever AI is used, it should be disclosed clearly. Bar Council accountability, which should clearly ban lawyers from using AI, ChatGPT, or at least the open source AI. Institutionalized legal LLMs. Like the problem is with regarding the use of these public models. Judiciary should at some point come up with its own LLMs, its own legal AI, which can handle this hallucination, which can handle the sensitivities of judiciary in a much better way. Human in the loop system. Human in the loop system means AI will be handling a lot of aspects to this, but at the end of the day, the final evaluation, the final decision will be made by the human. The final reasoning will be given by the human itself. The other parts beyond this will be handled by the AI. So that is a human plus AI collaboration. These are some of the systems that can have potential to use in judiciary in India. Being said, at the current level of where things stand, we still should restrict AI because of these huge concerns. Okay, going into the last article for the day. This is basically a report that has been put forward by UN regarding usage of AI, and it put forward some of these issues related to AI. Many of the issues we already discussed. One is digital neocolonialism, as we discussed before. There is a north-south divide in usage of AI, and there is a loss of tech sovereignty, complete loss of tech sovereignty to the south. Earlier, when industrialization times, it was regarding the textile, it was regarding use of petroleum and other technologies. Now the colonialism or tech divide is between the use of AI models. There is a divide between who design AI models and who uses AI models. Cognitive hacking, like one of the highest use cases of AI has been psychological helps. Psychological helps taken from AI by young people. by sharing their intimate personal problems, fears to the AI and finding solutions. Even though it has huge potential, again, people who cannot reach out to good doctors or mental health help, they can use AI to a great extent. But again, it comes with a lot of challenges. AI can give wrong advices. AI can manipulate people and push people to even suicide cases. There has been different suicide cases related to continuous chatting with AI or continuous attachment built with AI chatbots. Weaponization of disinformation, again, this we have seen in regarding elections in India, in Maharashtra and all. There has been deep fake videos, audios on leaders, on Modi, and so on and so forth. And the advancement in video technology, it becomes literally impossible for human eye to identify which is a deep fake AI video and which is an original video. So this becomes a challenge, and this becomes a question when these elections are happening. Data enclosures, collapse of information ecology. That means earlier we have same problem. Earlier we have a clear idea what is reliable data. Like we have news agencies, we have book publishers, which have some sort of authority or some sort of certainty. Now with AI, what is happening? AI is taking content from all these sources, and there is still no clarity on what is the IPR status of all of these. What is the intellectual property status? Who holds the data? Whether these companies can stop giving their data, their content to the AI, or how AI is processing their data. And there is a problem with how information is being handled with the advent of AI. Algorithmic contagion, this is related to the financial risk. Again, the different sectoral application of AI, it is being applied to financial stock market trading. It is related to this fund management, and all this, there is risk associated with this. Asymmetric cyber warfare, again, in US-Iran conflict, we have seen the cloud being again used for particular design of bombing, design of attack in Iran by US. So again, the question of how much of AI can be used in cyber warfare, how much of a greater advantage it can give to the countries who have this AI model access, and those countries, how disadvantageous position are those countries which doesn't have access to this. Even there was a case when US has attacked one school in Iran, and there has been so much of cry and so much of news regarding this. And this location identification, this target fixing, all this has been done by Claude's model. And who know whether Claude made a mistake in this? We still doesn't know whether it was a deliberate target or this was an AI mistake where Claude targets it and identified school as a potential target, and US carried out this attack. Way forward, some of the way forward for 5 pillars of AI, global AI governments. Ex-ante regulation and auditing. That means proactive regulation like EU AI laws. We need global laws. We need other countries to adopt some kind of grading in usage of AI. Grading means for certain applications, it should be open, free. But some certain applications, it should be closed. Some certain applications, it should be limited, and so on and so forth. Multilateralism and polycentric governance. That means there should be some UN organizations, some platforms where the concerns of AI can be discussed openly. Sovereign digital public infrastructure. India already has JAM facility. So this can be expanded to incorporate upcoming developments of AI. Epistemic independence. Again, AI sovereignty becomes a concern of the upcoming decades, and India should work towards this. We already have this India Mission AI, but it should evolve from using or developing applications of this neural networks or language processing models to something like developing our own language developing for models, at least for government sector, at least for defense and this public data management sectors. Cryptographic provenance and technoethics. This is something like there should be SEBI guidelines. There should be other regulatory organization, RBI guidelines regarding use of AI in those particular sectors, and this should be strictly enforced. Even in the Companies Act, the mandatory disclosure, the mandatory limitations should be put on to what extent AI can be used and to what extent and where all it cannot be used. So these are some of the way forward pillars. You can just learn some of the dimensions, some of the keywords, and use in your answers. These are some of the issues associated with the AI. So that is 5 top news for the day. That's all for now. Thank you for watching. All the best, and we'll see you tomorrow.